go ahead and, so we are now recording and Dave will begin in 1 minute.
Okay.
All right, it's now 1 o'clock and we're ready to begin.
Hello, my name is Dave Zapponi, and I'm the Executive Director of ECHO. Thank you for joining ECHO's live stream webinar, Back to Business, HOA Construction and Vendor Protocols After Coronavirus, featuring John Gill, founding shareholder at Hughes, Gill, Cochrane, Tinetti, and Bill Mann, President of the GB Group Construction. The Educational Council of Homeowners, also known as ECHO, is a statewide nonprofit association. ECHO is 47 years old, which makes it the oldest association representing collective interests of HOAs in the state of California. It prides itself on providing quality educational programs focused on building stronger communities. Our mission is to foster a better quality of life in community associations through education, advocacy, and connection. Before we move forward with the program, please be advised that attendees will be muted during the presentation. There will be a live Q&A session. Please submit your questions via the Q&A feature and not the chat feature of Zoom. The program will be recorded and we will send out the recording within 1 week of the program. I want to say thank you to our sponsors of this event, Hughes, Gill, Cochrane, Tinetti, PC, who is sponsoring the Q&A session, and OMNI Community Management Services sponsoring the registration. John P. Gill, Esquire, is the principal and founding shareholder of Hughes, Gill, Cochrane, Tinetti. John is a construction defect specialist with deep general representation in the HOA industry. He also serves on the ECHO Board of Directors. Bill Mann is the president of the GB Group, which provides construction services to the HOA industry. John and Bill.
Thanks, Dave. I'll get us started today. Bill and I are going to speak to you for the next hour about some of the challenges and new realities facing homeowners associations when it comes to construction projects in communities, whether they relate to projects that were already underway at the time of shutdowns or projects that you're trying to get started and hadn't gotten started when the shutdowns began. I think everyone is available. Everyone obviously knows at this point that the federal government and the state of California have issued declarations of states of emergency in response to the COVID-19 situation. And all of the counties in the state of California have issued a variety of shelter-in-place orders that have had a significant impact on our daily lives. We're going to talk about the impact of those various orders on construction projects. I think most people are aware, but we're going to talk today in some ways about how the counties, in many cases, have stricter restrictions imposed than the state of California has imposed, and these restrictions can have a significant impact on homeowner association repair projects. There are significant new safety protocols that are required by several counties. Bill and I are going to focus primarily today on the main Bay Area counties that in large measure have issued construction protocols for small construction projects and large construction projects. The Bay Area counties in this respect have been pretty much in lockstep up to this point with regard to construction. Some of the other counties that attendees may be more concerned about, Bill will be able to address them generally in terms of where they fit in the overall scheme. But the Bay Area in particular has two different types of safety protocols that we're going to address. There are significant additional costs that flow from these safety protocols and the new requirements. There are delays and extended completion times that are part of the new reality. And any construction project at this point in communities where residents are home is going to have an increased impact on the residents, both in the disruptions that are inherent to construction, but also recognizing that there is a lot of fear over the virus and people's concerns in that regard. So this plays out with two types of scenarios. One are construction projects that were already underway when the shelter-in-place orders were first issued, and Bill's going to talk about that in a minute. In those scenarios, we have to evaluate if there is a written contract. What does the contract language say about work stoppages? We're going to talk about a subject called force majeure, acts of God, unpredictable things that impact the contract. We'll get into that. And then the second general scenario is projects that were not yet under contract when the shutdown took place, that by definition now will have to incorporate going forward the new safety protocols and the burdens and expenses that go with those, whether it's additional costs, health considerations of the workers, of the residents, delays in project completion times. And the theme I want you to be thinking about as we go through this today, the theme for board members in particular, you really need to look at these construction projects through the prism of, do you view your contractor as your association's business partner that is helping your association solve a problem, or do you look at your contractor as your adversary? If your contractor is your business partner, there's one avenue to resolving these issues working together. If you look at your contractor as your adversary and there's a lot of distrust, it will have an impact on your view of who is responsible for payment of which additional expenses and how the project proceeds. So what we're going to talk about today, if we can go to the next slide, Bill, Mann, and I are going to discuss for the next hour or so the current state of association construction projects, both current and pending projects, the costs and burdens of COVID-19 compliance, both general, realistic, but more importantly, from a legal standpoint, the burdens and expenses that flow from the county health official orders that have to be followed. There are specific COVID-19 site protocols. Again, in the Bay Area counties, it's divided by large and small projects. Bill is going to go through those requirements in some detail, and all which will result in extended project times. And we're also going to talk about dealing with your residents and their concerns in how all this works. So I'm going to turn it over to Bill. If you could start off with how we got here.
Okay, so interesting enough, when we started doing this presentation, you go back and look at the whole COVID-19 series of events. It really started back in towards the end of January, where the first case of coronavirus happened in Orange County, California, which was quite a bit before probably a lot of us realized. Santa Clara declared their local health emergency in the beginning of February, which was pretty early on in this process. And then we started, certainly when the shelter-in-place implementations came in for numerous counties in the middle of February, we saw that coming all over the place. And then following that, the governor's stay-at-home orders and only operating essential businesses. The essential business thing was a little bit vague. A lot of people were trying to fit into that bubble of an essential business so they could continue operating. And then the governor created a list of safety protocols and requirements and then tightened down the list of what was essential. Saw all kinds of different things going on in the Bay Area related to construction. Unfortunately, a lot of people kept running job sites that weren't essential. Eventually, they cracked down on construction even more. So in 522, the construction opened back up, and most of the Bay Area counties, Napa was probably one of the first counties that opened up early. It was in the North Bay, slightly before us, with new safety protocols and guidelines. Next slide. So Santa Clara County Health Order of March 2020. So the work that ensures existing construction sites are safe and secure, work that responds to the current health crisis in the county, life safety, low income housing was definitely one of the priorities on construction at that time. So you saw all the housing projects that were low income continued to be worked on. And then we also saw a lot of our different facilities being converted into temporary hospitals and things like that during that. The order, specifically said that cannot be reasonably delayed. Unfortunately, some of the contractors that were doing things like painting and stuff that were tried to fit into that bubble, but were quickly shut down by most of the county agencies. The counties in the Bay Area were definitely more restrictive than our outlying counties out in the valleys and in farther north. And the restrictions in the beginning were all different county by county. As John had mentioned, as this rollout's been going on, the Bay Area counties have been much more in line with each other on how the ordinances are working.
So as we go on to the public response to state and county mandates, one thing, a lot of people have questions about pools and some of the other common area amenities and vendor services. We are not going to talk about pools in particular. That is a really well sought out subject right now in today's webinar. This is only about construction, but ECHO is dealing with that in other ways. I believe there is a Southern California online conversation that is being scheduled for tomorrow afternoon at 4 o'clock that deals with Orange, Riverside, and a couple of the other Southern California counties that Dave Zapponi maybe can address at the end of this presentation today. And also next Thursday, ECHO has scheduled another webinar that is going to do with the reopening of communities generally. And pools will be a topic of discussion with regard to, in that webinar. That's next Thursday at 1 o'clock California time. So the public response to the state and county mandates, and again, this goes back to the original shutdown a couple of months back, and the legal and political realities that arose then that still exist now, just under some different circumstances. Board approval of projects, but residents retaliate. Everybody is now at home. Many people now are working from home. They're homeschooling their kids. They have different realities of having to function while making a living and taking care of the families, all sheltering in place. And there's not only is there a disruption from construction that is felt more strongly by more people now, but there's also a fear of anyone coming into the community potentially spreading the virus. And so while boards have wanted to proceed, residents aren't necessarily all on board. Public shaming, greed accusations, when people are afraid, a lot of things come out that otherwise might not come out so readily, and residents have reacted pretty strongly in some cases. In many cases, the city building departments were issuing permits, but associations have been reluctant to proceed. Legal opinions often are varied in terms of whether associations should proceed, legally can proceed. I have had clients that have wanted to kick the issue of whether the association should proceed with a major construction project to a member vote, And without going too far into that subject here, that is not the type of issue that the board can defer to the members for a member vote simply because people care about it. The board members have a fiduciary duty to make decisions in the best interest of the association, which includes whether to proceed with significant construction work that otherwise is needed. At the time of the original shutdown, most contractors reacted either by terminating the work or making everything watertight, which isn't fully repaired, but it's keeping it safe and protected from water intrusion and essentially putting the projects on hiatus. Schedules automatically became delayed, either because they were put off or because the time necessary to do the work increased significantly. And the counties at that point started implementing new rules and regulations on how work began to be enforced. Those have been modified more significantly, and in a few minutes, Bill's going to go through in significant detail some of those protocols. So the above factors still exist under the current county health officer orders as reflected in the protocols. These issues haven't gone away, and they're not going to go away anytime soon until people start dispersing back into the workplace and back into everyday life. And when that happens, it may vary county to county, but it's really anybody's guess at this point. And these issues have to be taken into account by board members in deciding whether to proceed and under what circumstances, recognizing that the board has a fiduciary duty to make prudent business decisions. And some of that relates to, can you really wait to proceed with a construction project when there are life safety issues and health issues at stake? So one of the topics, if we go to the next slide, one of the topics that has become pretty prominent, this is for projects that were already under contract when the shelter-in-place orders began to be issued, is the concept of force majeure. Force majeure is a legal term, and broken down in simple terms, it relates to events or circumstances that are A, beyond the control of the parties. In this instance, it's beyond the control of the contractor to proceed. These are circumstances or events that were not foreseeable when the parties entered into their prior agreement, and then make it either impractical or impossible to comply with the contract terms to the letter. Common examples: acts of God, a tornado or a fire, or in this case, a virus. Does a virus meet the definition of making it impractical or impossible to proceed? Well, maybe, maybe not, but there are a lot of things that go into that, including issues that Bill can address in a few minutes related to the availability of contractor personnel, given that the contractor personnel have the same challenges of having to take care of their kids, take care of their family members, homeschooling, all of those things, and the availability of materials when factories and production facilities have shut down. So the issue that comes up in this context is who's responsible for delays and extra costs when we're talking about force majeure. And you want to look to the written contract language, but we also have to look to reality and the whole concept of whether your contractor is the association's business partner or the association's adversary when something unexpected comes up. So how do we apply that to the COVID-19 situation? Well, the virus, in some respect, is a natural event. It can be considered an act of God. It's probably was unforeseeable when the project bid. Now, that may be on a case-by-case basis in terms of what was known when and when the bids were actually handed out. It's clearly uncontrollable by the contractor, an insurmountable event that it can't be worked around entirely. It can't be disregarded. There are ways that the counties are saying to work around it that increase time necessities and costs. It's not the fault of the owner. It's also not the fault of the contractor, which all gets back to the acts of God that nobody could have anticipated. It clearly significantly disrupts the progress of the work. It may make the contractor unable to fulfill its obligations to the letter of the agreement, making it impractical or impossible if there aren't enough personnel or there's inability to obtain construction materials due to factory shutdowns. The time of performance requirement by definition is going to change. And it can be adjusted by prior change orders, variations, and time extensions. It gets back to the additional unanticipated costs and burdens. The costs are the biggest concern for most board members. These can be considerable. Bill's going to get into them in a bit. And again, the immediate reaction that we see from many boards is, hey, we have a contract. This is the contractor's problem. Well, A, the contract may not say that. And B, if the contract is silent, or God forbid, you really don't have a written agreement, the question is, do you want to get into an adversarial litigation proceeding with lawyers, with additional costs, and with a court that may disagree with you about what the contractor should have known and what the contractor's problem is that board members think shouldn't be the association's burden to bear. And courts are going to look to reasonableness in all this, and we are in a period of time that no one has ever really been through in this country or in the state of California. And what board members might consider reasonable in this context may not be shared by anyone else, including judges and juries. So, Bill, if you could start talking to us about some of the additional costs that contractors will have to incur and that should be dealt with boards.
So these are kind of the things that came up when we first had the shelter-in-place order. If you remember, it was only a 2-week order initially. And we were also in the middle of winter. So a lot of the sites didn't demobilize and then eventually remobilize. If we'd known, I think in the beginning, that the shelter-in-place was going to be extended, there might have been job sites that we would have decided to demobilize on versus keeping our yards and equipment there. We did have ongoing site safety concerns, so we had to have employees still go out and check job sites regularly for safety issues, particularly if there's scaffolding and different things on site that required security, check our yards, and all the different things that we have going on at the project. The other thing that was probably more important on quite a few of them was weather protection. So a lot of the sites were in the middle of construction, and so temporary weather protection went up, hoping that we'd be back to work in 2 weeks. So that had to be regularly checked during the storms to make sure that the buildings were kept watertight and we didn't end up with some huge water intrusion problem while everybody was sheltering in place in their homes. The other thing that we had to do during this process is that the health directives started coming out for employees. So we had to set up a new training protocol for the employees that were working. We had to go through learning curves with that. I'm not sure how many Teams meetings we had going through developing the IIPPs that were constantly changing regarding site safety and training. And then our safety department would have to had to start implementing that and training the employees. Some of the sites that we closed up, we particularly had a couple of them where we were doing shear wall repairs, and so things were put back temporarily. So a lot of it was covered up temporarily, so a lot of that had to be reworked. We had to go remove all that stuff that we'd put in temporarily and then rework the sites on that. Fortunately, we didn't experience any vandalism, but I can't say that all my fellow contractors had that same experience. So some of the other things that we're running into is we're ramping back up. As we're seeing an increase in material prices. One of the things that seems to happen a lot during different issues is sheet goods like plywood, OSB plywood, things like that. While we were having a fairly normal winter here, there were a lot of tornadoes and things on the East Coast, which board ups and stuff require a lot of sheet goods. Then we had a lot of businesses in the Bay Area closing. So if you drive around to the retail areas, particularly in the more urban markets like San Francisco, downtown San Jose, Oakland, all the businesses are boarded up. So sheet goods became very hard to get and the cost increased quite a bit. The other material costs that started going up as we started going through ramping back up is plexiglass, as everybody started putting up all their guards and stuff at the checkouts, the lobbies, our office, those kinds of things. We're seeing some increase in labor costs. That will stay fairly level. Equipment costs have gone up, particularly on stuff that's in high demand, like wash sinks, things that are related to safety, PPE items such as masks, gloves, sanitizers, all that stuff is increased tremendously due to the demand. We had, expenses with idle yards, equipment on site, scaffolding, things like that. We had ongoing insurance and bond costs. The other issues that we had is that the staff that was operating, they weren't at the office, they were operating from home. So that created some inefficiencies and also some increased expense on our side. So the administrative issues have been dealt with. Thank God for things like Teams meetings and stuff like that, because I can't imagine of going through this with some of the old technology we had. So it's great that Zoom and all these companies have kind of stepped up to the plate. As we ramp back up, we're bringing back our staff. Our office are going to be basically fully open next week. We're dealing with things, as John said. We just got a request from an employee that needs to be home with their child, so wants to stay home, work from home 3 days a week, and come in too. So those are the kinds of things that we're having to work around and work through as we kind of do this restart in phase 2.
So one of the issues that associations need to deal with, if boards understand that these unexpected, unforeseeable, and uncontrollable things are increasing the contractor's cost, and you recognize that doing battle with your contractor over whether they are responsible for absorbing all the costs of flukish, unforeseeable events, which I don't think a court typically would support that view, is where do you get the money for the additional costs that otherwise, either by contract or general legal principles, would be passed through to the association? You always have your reserves. To the extent you've got additional reserves, it would be an appropriate use of reserves. You can attempt to get a construction loan to bridge the gap. Maybe that's already been done. And the question is, how do we go back to people and ask for them to vote for a special assessment when when they've already been through that and they're not gonna wanna do that again? This is a scenario where boards may wanna consider an emergency assessment under Civil Code Section 5610. There is no limit to the amount of an emergency assessment. There are obviously political and practical limits to what people may be able to pay, but we're not talking about the entire job costs. We're talking about the additional marginal expenses. An emergency assessment is an extraordinary expense necessary to repair or maintain the common area that could not have been reasonably foreseen at the time the prior year's fiscal budget was distributed and is now necessary. And in order to levy an emergency assessment without a member vote, the board has to adopt a resolution with written findings regarding the necessity of the emergency and why it couldn't have been foreseen. This is not what anybody really wants to do, but there are avenues to raise funds for the additional costs that you didn't anticipate.
Now, John, could they pass that emergency special assessment as a monthly special assessment in case this order gets lifted during the construction projects, or would it have to be a one-time deal?
I haven't thought of it on a monthly basis, because at some point you could have an emergency assessment conceptually that would be this much per month while these expenses are being incurred on a monthly basis. But that's probably more complicated than we can get into today. You want to talk to your legal counsel about this subject. Generally understand that emergency assessments should not be the norm, but we are in a state of emergency, and this would often meet the definition, and it's something you should talk to legal counsel about.
So one of the things we're going to be basically going over, and I apologize for people that are outside these counties, we can kind of touch on that a little bit, but these are the basic Bay Area counties that have put in the same exact order related to construction, and then Sonoma kind of added themselves a week or so later. And there's basically 2 stages to this construction. I'll go into the different details and items on that. And then we can also talk about some of the counties outside this area. So one of the things that is the state turned controls over the counties. We had the majority of the Bay Area counties allow construction to return. Part of that protocol, when it came out, mandated by size in the Bay Area counties and Sonoma County. So they have basically two different size and two different protocols. So we have a small protocol, which is less than 10 units for mixed use, and a large protocol for more than 11 units. There's a separate protocol for commercial properties, which is based off of square footage. I think the important thing here to realize is, you know, if you have a contractor coming out to work on one single unit, that would definitely be a small project. If you have somebody coming out and painting multiple units that are over 10, even if that's multiple buildings, you would fall into the large protocol. The other things I want to make sure is, you know, we have a lot of associations say, you know, we're in our little enclave here, you come through our gate, you know, the city doesn't come in here. As John kind of mentioned, as construction's going on while everybody's sheltering in place, we're, you know, having a lot more homeowners get upset with the noise as they're trying to work from home and school their kids. So they're calling the officials and complaining about things like this. So, and we've had it happen already, not only just the public officials, but news media as well. So you need to realize that even if you're in a gated community, these protocols are gonna apply to you as well. And right out of the gate, we had large commercial construction company in Santa Clara that was building low-income housing that the fire department came out and cited for violations.
Can I say one more thing about this before we move on? I have been asked questions, and I believe the Bay Area County orders that Bill is about to go into for small construction protocols and large construction protocols, these took effect, if I recall, on May 8th. It was the first week of May. And so we're really just starting to dive back into this. And one of the questions I've had from board members and some managers is, who makes the decision of whether to follow small construction protocol or large construction protocol? And of course, boards that figure out that the costs of compliance are going to pass through to the association to be able to complete the work. Many boards are hoping that as much as possible gets put within small construction protocol, because as Bill's going to talk about, the large is more burdensome and more expensive. Board members absolutely do not want to get into the mix of making a decision or directing which should be followed. These are requirements that contractors are required to comply with based on the directives of the county health officials. Board members are protected if they defer to the responsible party to ensure compliance without dictating the terms. So the board members, the board's perspective in this with the contractor is, contractor, you have to comply. Please keep us informed. Please confirm your compliance. Give us assurance that we can pass through to our members when we get questions. But if board members start diving into the issue of, should this be small, should this be large, we shouldn't have to do this, board members are potentially taking on personal liability for making decisions that are beyond theirs to make, and you're best protected by deferring to the responsible party for compliance, which is the contractor, which has every interest in making sure that legal compliance occurs.
Okay, so small projects, which is up to 10 units. So if your association is outside the Bay Area counties and Sonoma that we just mentioned, generally your construction projects are all going to follow within this protocol, but you really should check the specific directive from the health department, because they do vary some. But this will generally give you a good idea of what's going to be required on your projects of any size, because they did not delineate between large and small. But for the fortunate folks here in the Bay Area, we do have a lot of different protocols we have to do. So on a small project, there has to be a designated supervisor. So each job, small or large, has to have a protocol set up, guidelines. I just looked at one. Ours are about 31 pages long with all the site requirements and everything. And in that document, you have to designate the supervisors for that project, large or small. There has to be a protocol plan in place, and that's what the document has. There has to be training of all employees, so that all has to be documented, that they've all been trained on this protocol and understand it. The site supervisors have to do daily reporting, so they're noting all the different workers that are on site every day. They have to note any visitors that come in. They have to take people's temperatures and different things while they're doing their daily screening. So the daily screening is basically some of the things you've probably been asked if you've had anybody come out to your home. Has anybody been sick? Have you been exposed to anything? All the different requirements, you know, that you have to go through. So these are all things that they have to do in the morning before they start the job up. Social distancing is required on job sites as much as feasibly possible, which creates a little bit of interruption in the work paths and stuff. So that's kind of one of those things that's very difficult to do. We need to block off work areas, and if we're doing interior work, it has to be completely sealed off. Very similar to if we were doing a mold or asbestos abatement. It's not just putting up dust protection. It's a lot more inclusive. And then there's also issues what we have to deal with decontamination of those work areas. They'd like us to set up alternate entrances from the public. So if you have a maybe rise building or high-rise building, maybe if there's just two doors, the community uses the front door and the contractors are coming in and out of the back door. Those are things they'd like to do. They'd also like us to do alternate entries and exits for unit work if we're going through units, which is difficult in most communities. The other thing is the gathering for breaks. So there's no eating and gathering for breaks like we typically, so everybody has to disband, practice social distancing. One of the big things that, you know, has become very popular at lunchtime with the construction workers is they have microwaves now. They run off their generators. They have little cooktops and things they bring out. So no more, we had to shut all that down. No more shared food, no more coolers. Everybody goes and eats in their separate vehicles, and they all practice social distancing. So it makes for a less commemorative job site. So one of the other things is the PPE. So we had some issues with this when the orders first came out. The PPE requirement for masks from OSHA required what they called an N95 mask, which is deemed medical grade mask. Then we had county health ordinances that said we weren't supposed to use N95 masks. They were supposed to be allocated just for medical use, and we were supposed to use cloth masks. And those are some of the things that we've had to deal with these ordinances. So who do we follow? Who has jurisdiction, OSHA or the county health officer? So those are things that, you know, we've had to go through. We had to send emails to OSHA to try to get, you know, at least some kind of verification of where their policies were going to stand during this crisis. Staggering the trades. One of the things that they've required that's in the protocols is they want us to stagger the different trades on the job site so that they can practice social distancing. They don't want shared tools. If we do have shared tools, they must be disinfected between uses. Hand washing facilities at multiple locations. So most job sites required to have 2 hand washing stations. Sometimes that's difficult depending on the site requirements and the amount of space we have, as well as availability of hand washing stations. We've had to come up with some alternate things as they were kind of in tight supply initially, because a lot of them were at temporary medical facilities, but they seem to be becoming a little bit more available right now. But the cost of them is doubled from what it used to be. A hand washing station used to cost us about $45 a month. Now they're $95 a month. So, and now we have to have 2 of them, where before I could just have a hand washing station that was part of the portalet. So those are things we're having to deal with. The other thing we're having to deal with is things like the hand washing stations, the restrooms, and the other high touch areas in the workplace. I have to have an employee go around and sanitize those on a regular basis. So now we've got somebody going around doing housekeeping chores on the job site continuously during the day, which is additional expense. We talked about the daily visitor log. There's also a lot of notices. One of the businesses that if you haven't bought stock in would be a sign company right now, because we're buying signs like there's no tomorrow. And we're having to post them all over the place. I think one of the more significant things when this ordinance got in place, and I'm not sure that some of the officials, I understand the reasoning for it, but I'm not sure they understand the impact, is no carpooling. So typically speaking, because most associations have parking issues already, before we get there. And now we've got everybody home during the day. So visitor parking is usually already full, and a lot of associations are dealing with parking issues because everybody being at home. Well, suddenly if we have a 20-man or 10-man crew showing up to your job site that came in a van, one van, and now they're coming in 10 or 12 trucks, it creates a whole different issue. And there's some job sites due to this parking situation that may need to reconsider whether or not it's feasible going forward until the shelter in place gets lifted and some of the residents start going back to work, because some of the facilities just don't have the parking for us to come in with any kind of crew size to do the work. And so we'll see what happens with that over time.
Bill, just with regard to the small construction protocols that you've just gone through, I'm thinking of time of completion of a project. If you have a standard 8-hour workday, how much is that standard workday from a productive standpoint diminished by the need to do all these things on a daily basis? What would you estimate? 10%?
Well, so on a small job, I probably estimate you're reducing productivity once you get this streamlined, at least a half hour per employee per day. And then you're going to have a few extra hours, with the project manager and, having an employee run around sanitizing things. So we figuring another couple hours a day of that time. So it can be fairly significant when you start multiplying out the hours on a per day basis per week. So large projects, this is 11 units and more. So they have the same protocols as most of the small projects. The one thing that's different is they have to have a daily safety meeting in the morning. So when the project crew gets there, they all have to meet and they all have to go back through the safety protocol for COVID-19, which is not a small thing. It takes about 20 or 30 minutes to get through that. They also have to do all their temperature checks during that time. They also require in these large jobs that the site is sanitized in the morning before we start working on it, and as well as when we leave in the evening. So that's kind of one of those things that, depending on the site, depending on their scaffolding, different things, the sanitation time is pretty extensive. The other issue we have is we have to do a lot of signage for choke points. So if there's areas, particularly in scaffolding or tight areas on the site, we need to put signage where the employees understand that they need to wait until the area is clear before they're passing through, so they're not passing through on top of each other. All the signage on site has to be in English as well as in Spanish. The signboards, just to get an idea of the volume of all the different signs, the signboards have generally been on about a 4x8 sheet of plywood, and they've pretty much filled them up. So we also on site, and this can also be a problem, particularly in some of the high-rise and mid-rise buildings, we have to set up a decontamination area where we can bring tools and materials and stuff, as well as employees' PPE back to be decontaminated. Sometimes the sites aren't having a lot of areas to do this, and it gets to be very complicated on what to do this. As I mentioned before, every job has to have a special site protocol. The large site protocols are a little bit more detailed, related to, we have to go through what the scope of work is. We have to demonstrate how we're going to separate the trades and stagger them through the project. It all has to be done. It has to be on site for everything. And these are pretty substantial, and they're county specific. And so we have to have them for every single job in every single county. So there was a fair amount of office time that took, and administrative time, as well as management's time to go through and set up all these protocols to make sure they complied with the regulation. The other thing about the decontamination that, I think people misunderstand decontamination. That's not just going and spraying some Lysol on something and walking away or wiping it down. Sometimes you have to spray things down depending on what product you're using. It may have to sit there for 10 or 15 minutes before you wipe it down in order to be effective. So part of the whole process is you have to delineate the products you're using and understand how they work. We also have to, no more water jugs or anything on site. Everything has to be single serving water containers. We also, as I mentioned before, for interior work, it has to be under full containment, which, you know, takes up a lot more space on interior. There's zip walls and things that have to be put in. And as I mentioned, at the end of each workday, the crew has to decontaminate the containment area, which is something even addition that you'd have to do during a mold or asbestos abatement. So we're not going to see, I'm hoping not to see anything interior wise that isn't essential. So most of the projects we're on, if it has interior works, that's kind of on hold at this point. So as we consider here, here's some more issues we have to do. So the COVID-19 compliance safety officers name and number has to be posted. So these are the employees that we have on site. They're in charge of the COVID-19 protocols. We have to have the remediation plan if we contaminate the site available and on site. So if somebody does end up affected by COVID-19 that's on the crew, there's a whole process that we have to go through to decontaminate the site, bring in a third party to do so. One of the things I think, John, is we would notify the board, and I think you probably would want to talk to the board about how to notify the employees or the homeowners if something like this happened.
So in a situation like that, yeah, the first line is the contractor would discuss the situation with the board, and there would be some measure of a shutdown to allow for the protocols to be implemented. The question then that boards are going to have is, what do we tell members, if anything, about what's happening based on this this circumstance? There is not a one-size-fits-all answer that I'm willing to give everyone here that say do this and you're safe. It really depends on the circumstances, and boards need to consult with legal counsel about whether there is an obligation to make a disclosure, and if so, what should be disclosed. There are medical privacy issues involved. There are obviously health, safety, and security issues involved for the residents. And again, there isn't enough time to really get into all the factors. When the board is advised that that something like this has occurred by the contractor, the board needs to consult with legal counsel. Bill, I've got a couple of other questions for you. You talked about small safety protocols. What with the large construction project protocols, how do you see this impacting the productive workday in terms of amount of time?
Okay, well, let me finish the thing, because one of the things that's interesting in this protocol, it came up really at the 11th hour, caught us very much off guard when the order came out, because we hadn't seen it in anything previously, is in the order for the Bay Area for large projects, it says the contractor has to, we have to contract with a third party job site safety accountability supervisor. And this person is a third party, it's not can't be part of our company. They have to have a OSHA 30 card. They have to have, I think, a first aid and some other things. They have to come out to the site, assess it every day. They submit compliance to the county, and if compliance isn't met, they can shut the job site down. So this is actually something that's pretty significant because now we're dealing with a third party that's coming out. There's obviously a cost attached to that to have them come out and do this thing. And it wasn't like we all had, you know, I use an old term, I just went to my Rolodex and found out where are my COVID compliance officers I can call. So it was an interesting thing to locate and find somebody to do this. But we've set it up and the process is in place and we're moving forward with that. As far as costs, on a large job, we're looking at a time spent per average employee of about 45 minutes versus the half hour on the small jobs to deal with all the compliance issues. Also, we see project managers' time at least 2 hours a day dealing with all the paperwork, as well as monitoring everything. And then we have additional expense for a lot of sanitation projects, since we're decontaminating the site or sanitizing the site in the morning and in the evening, and then all the extra expense for the PPE. So we're seeing costs. I do a lot of litigation estimating and cost estimating for projects that people are budgeting for. And the industry is kind of a little bit all over the map, but we're seeing numbers coming anywhere from 7 to 12% of the project costs just to deal with the COVID-19 compliance.
And in terms of completion time, if you have a multi-month significant repair project in a condominium community, for example, and a minimum of 45 minutes of every day, of every 8-hour day, is taking your personnel out of the repair work business and into the compliance business. I haven't done the math on that, but you're looking at 8 to 10% loss of productive time that, if everything goes well, would extend the period of completion accordingly to be able to finish the project, right?
And that's true. And the other thing that goes along with that is just all the general conditions to run a job that you have every month that now have got extended out. But you're right, it's about 8 to 10% extension on the completion date typically too. And a lot of it will depend on the job site. You have a really super tight job site with a lot of choke points and stuff like that. You have to man down the crew. It may double the time it takes in order to do the work. If you're dealing with a mid-rise or high-rise with elevators and other things, it's much more difficult to operate in those buildings right now, and takes a lot longer than it used to.
One last question for you, Bill, on this subject. If a contract hasn't been finalized, but bids were already submitted, and now we're in the new reality, are you seeing associations and project managers and architects asking for requests for confirmation of the prior bids? What's being done to account for the additional burdens when you're not under contract yet with prior submitted bids?
Well, I mean, some of the projects we were in the middle of contract negotiations, so we'd already been awarded. So those we're having to add the COVID expense to. And what we're doing is we're coming up with a weekly cost. That way, if the order gets lifted, we can just not bill for it any longer. Some of the newer projects that where boards hadn't even reviewed bids, construction managers have come back and asked us to review our bid and add cost. The thing that concerned me, one project, probably the first one we were asked to do, which was last week on that, is the construction manager came back to me and said, I have contractors coming back and saying that there's no additional cost to comply with the COVID-19 site protocols. I said I would go and get a copy of their protocols because they clearly don't understand the impact of this, that they think there's no cost attached to it.
And in terms of the additional costs, boards need to recognize that compliance is essential. The board wants to be able to defer to the contractor to ensure compliance and give the boards assurance that compliance is occurring. But boards also need to recognize that these things aren't done for free, and you don't want to cut corners on costs when it is for the protection of public health and the protection of all the residents in your community. So this does get back to the concept of looking at your contractor as a business partner to work with the association to ensure that everybody is protected. And again, so we have small project construction protocols, large project construction protocols. You want to defer to the contractor to determine which apply. You may want to ask some questions about why, but I would recommend you don't direct them as to which apply, because at that point, once you take that step, I think the board members are in the soup of being responsible for non-compliance in a way that otherwise you wouldn't be.
And if you have a project that's currently out to bid, since this is fairly new, I would make sure and have either your construction manager or your community manager, or if you're self-managed, I would request a copy of the contractor's COVID-19 protocols for your county, and have them include that in their bid package.
Absolutely. So we want to leave some time for questions. We'll wrap this up. The next slide is managing expectations. Communication is essential. It's essential in everything we do with our communities. It's definitely essential here. Communication between the contractor and the board, the manager, if you have independent management, between the board and members, between the board and legal counsel, to make sure that the board is getting all the appropriate information, making informed decisions, and being as transparent as is warranted and reasonable under the circumstances, recognizing that the contractor is responsible for compliance with all these obligations, but the board wants assurance, both for the protection of the association and to reassure the members without actually dictating the terms. In my experience, it's not unreasonable to assume that we're going to have some members that want to get in and start second guessing things. And it can be a little bit dicey trying to figure out how to juggle the concerns of everyone. But the board members are the ones that have a fiduciary duty to make sure the association and the members are appropriately protected legally. And you want to stay in touch with your legal counsel to make sure that you're complying. The final slide, will the job cost remain the same? I hope by now everyone recognizes the answer to that realistically should be no, and realistically should be that association boards need to recognize that the costs of doing business at this point and the costs of making necessary repairs inevitably are going to increase. And rather than get into an adversarial situation about whether these things were foreseeable or whether it's reasonable for the association to have to pay more, you may need to reevaluate the scope of work to account for the increased costs that you don't want to nickel and dime when it's the protection of public health and the protection of people in your communities. There are a variety of things here that we've already discussed that I don't need to go through here. But again, one of the biggest challenges in all this, construction projects already can be disruptive even when they're necessary, but with everyone at home, there are some additional challenges that everyone has to wrestle with. And the protection of the health and safety of everyone involved is paramount. And we all need to be more flexible in figuring out how to make that work for everybody.
One of the things I do want to touch back on, because you briefly mentioned it, is the material supply chain issue, as well as availability of products. So we've already seen on the jobs that we've ramped back up, typically we'd be able to get a lumber order in a day or two. A lot of them are getting stretched out to 6, 7, 8 days because they're trying to source all the materials. One of the other problems we're having is particularly with window manufacturers. Most of the Bay Area window manufacturers plants have all been closed. Hopefully they'll be reopening here soon, but they're also having to gear back up to deal with all their social distancing requirements on how they're going to operate. So if you do have a large project with any specific material requests, you may need to look at substitutions either to finish it or in order to get a new one started. And I think you're gonna have to look at lead times, because lead times are, I think, gonna get extended out significantly on different things. And then certainly any of the raw materials and stuff that we use for products that come in from out of the country, China and Canada, delays with those being coming across the border. So we're seeing issues just on raw materials for a lot of these factories, even in the Bay Area, to operate again.
So we ran a little long in the presentation. We may have answered some of the questions that people have, but we do have time for questions and answers, and we'll stick around and answer them if people have questions.
All right, thank you. So now I'll go ahead and open up the Q&A and we'll get to some of these questions. So towards the beginning of the presentation, we had a question. We had significant scaffolding on our building that went unused for several months. Who pays for that? Scaffolding company, contractor, or HOA?
Well, as the contractor, it's going to get passed on most likely to the HOA.
For certain types of specific questions like that, we can talk in general terms, but no one should assume that what you are hearing here is legal advice that you can rely on in the absence of consulting with your legal counsel.
I will say I would, for that association, I would probably go back to our scaffolding vendor, since it wasn't like he was going to be able to go move it to another job site. So there's not lost opportunity costs for him. And typically it's just a monthly rental after it's been erected. So there might be a way of getting some of those fees waived or at least reduced.
But anybody with specific questions about your individual situation, we want to make sure everybody understands you need to seek independent legal advice as board members to legally rely on it in a way that protects you as board members.
Next question. If force majeure is not in the written contract, can the contractor still have a valid force majeure defense to contract performance, or must force majeure be in the written contract?
So I'll speak in general terms again. Many contracts, the AIA contract forms that many are familiar with, I don't think the standard terms and conditions have a paragraph called force majeure, but you do have issues related to time of performance, unforeseen events, uncontrollable circumstances, and it may exist in a written contract in those forms. Beyond that, the fact that there isn't a written contract term related to things that could be construed as force majeure doesn't mean that a contractor legally is going to be stuck with uncontrollable, unforeseen costs in the time of a pandemic. So again, you want to get individual legal advice in your given situation. It's helpful if the contract defines it, but the fact that the contract doesn't define it doesn't end the question. It simply takes you in a different direction in terms of what's reasonable to expect in performance under all of the circumstances. And I do think boards need to get comfortable with the idea that putting this all on the back of the contractor and potentially eating up the contractor's entire profit on a significant job based on a virus that nobody 6 months ago had any idea we were going to be dealing with, in most cases might be considered unreasonable to assume that it's all the contractor's burden. At that point, you do need to get legal advice.
Okay. And our next question, which protocol would apply if doing work on only the clubhouse of an HOA? The work is only on freestanding building in the common area of a mobile home park with more than 10 units. I would assume it counts as large, but can you please clarify?
Since they're not working on the actual mobile home units, they're just working on the clubhouse, I would consider that one unit in a small project.
Okay. And does the rule apply also to landscapers and regular maintenance contractors, e.g. gutter cleaning?
Well, the protocols that we're talking about here, which for the Bay Area counties, the shelter-in-place orders from the health officers, they have an Appendix B1, and anybody can find these online if you want to go read them. So San Francisco, Contra Costa, Alameda, Santa Clara County, they're all branded for each county, but the health official shelter-in-place orders are largely the same, and I think they're identical at this point with regard to Appendix B1, which is small construction project protocols, and Appendix B2, which is large construction project protocols. I don't have them in front of me. I don't think they apply to maintenance, landscaping, gutter cleaning. They talk about construction specifically, which doesn't mean that there aren't other provisions of those orders that would apply to such things. I know the definition of essential businesses deals with landscaping, for example, and that's really beyond the scope of this webinar. But we will be talking about those things a week from now with regard to reopening communities.
Okay, and we had an attendee asked to restate the definition of a small versus large units.
Okay, so small units would be if you're working on 10 or less units, and then a large project would be 11 or more.
So Bill, if, again, every situation may be unique, but you have 100 units in a condominium development, you have 20 buildings with 5 units. One building has a fire and requires reconstruction. So you're doing repairs on a 5-unit building in a 100-unit development. Would that typically be the small project protocols?
Yeah, I'd interpret that as a small
Okay.
Okay. Our next question, you discussed potential actions if a contractor is discovered to be infected. What happens if a resident at a complex turns up positive?
if a complex turns up positive.
If a resident at a complex turns up positive.
So that's really my initial reaction to that. And we've been dealing with this for the last few months with communities where either at the beginning when residents started self-quarantining and announcing that they were self-quarantining, particularly in some of the urban condominium buildings, the construction protocols relate to contractor performance and protection. So the Appendix A and Appendix B in the health officer orders doesn't apply to the situation with one of the residents. And again, it really, so what we're presenting to you today wouldn't necessarily pertain to that. If an association is advised that one of the residents has a positive COVID-19 test result, and the board has questions about that, you should consult with legal counsel who can evaluate all of the circumstances related to what the association has been advised and give relevant advice on what, if any, steps the association, the board ought to take. But that's really not a construction issue.
Okay. Yeah, it looks like we're getting a lot of questions that are like for annual tree maintenance and landscaping contractors. Is that the same? So it looks like there's a lot of questions about that. Again,
these health agency orders are online. You can Google it. The Appendix B1 and B2 relate to construction projects specifically, not really in the nature of landscape maintenance.
Yeah, you can go to the different sites. I know that particularly when I was reviewing them early on, the different counties had different regulations on landscape maintenance and tree services and irrigation repairs and stuff, and all those kinds of, I would consider more ongoing maintenance type services.
Okay. Is there a current restarted project with an existing contract that states that all federal, state, and local laws and ordinances and safety regulations must be met during the course of the work? Wouldn't the costs of continuing the contract and work with the additional burden of COVID-19 protocols have to be borne by the contractor and not passable to the HOA? And I can restate that. That was a lot.
So I've seen contract language has this specific type of clause in it that the contractor is responsible for complying with all federal, state, local laws, ordinances, and safety regulations. And so does that mean that the contractor bears all such costs, including those costs that could not have been foreseen at the time a bid was submitted, at the time a contract was, a written contract was signed? There's a difference between the contractor being responsible for compliance. That's a statement of law anyway, and it's reiterated in that contract language. Whether the contractor can be legally held responsible for those costs, you would need to get independent legal advice. There isn't a one-size-fits-all answer, but I would caution you against assuming that any unforeseeable act of God, including a virus and the current pandemic that nobody knew about at the time the contract was entered, automatically becomes the contractor's full financial burden. I don't know that we haven't had a case that's interpreted that in court, to my knowledge, in California. There are analogies we could go to, but I think it does get back to, are you getting the benefit of your bargain with the contractor when nobody expected the world to come to a standstill 6 months ago or 9 months ago when the contract was entered, and now we live in a completely different world and different scenario? Is it a, hey, too bad for you, contractor, deal with it? I don't know that that's how it's going to end up in a court action. And it certainly puts your contractor in a position of scuffling to survive the project simply to keep the doors open, which isn't what you want when you're trying to ensure the health and safety of the residents of your community. So we need to look at this in bigger picture terms. But I cannot tell anybody that contract language means it's all the contractor's problem financially.
Okay. Does it seem reasonable to postpone projects until shelter-in-place orders are suspended? Do you think these costs are permanent?
For the latter, I would defer to Bill in terms of your thoughts about that going forward.
Well, even when the shelter-in-place order, which is basically going to be up here next week, these requirements, until they're actually lifted by the county health department, may continue for some time. We're not sure how long that's going to be. You know, there are some projects. We have a few that are stopped right now that are heavy interior work. It requires us to work on almost every room in the unit. And as why people are still working from home and stuff, I don't see those maybe continuing right now. If you had a large window replacement project that would require us to set up a lot of containments on the interiors, unless it was, you know, immediate for water intrusion issues, those things you might postpone. You know, it really kind of depends on the severity of what you're doing and how urgent it is that it needs to get completed.
Okay.
So in terms of whether a board should proceed to authorize a project to begin or recommence, you need to evaluate all of the relevant factors and do a cost-benefit risk-reward analysis, get reliable information, and make informed decisions. You want to take into account the visibility on how long this may extend. Nobody really knows. That may be different county to county as well. In fact, it will be different and is different county to county. You want to take into account the fact that your residents are home much more often and more affected. You want to take into account health and safety issues related to deferring construction. There may be contract issues if you have a written agreement about not reinitiating work when the contractor is otherwise available to proceed. You're going to need legal advice in that regard. And there's also the reality that, let's assume, just for the sake of discussion, that 50% of the pending projects don't restart right away. And that 6 months from now, somehow magically, everything is better and everybody's back to normal. And therefore, everybody is back wanting to reinitiate old projects and take on new ones. Well, there's the same supply of construction professionals available to do them. That's going to affect your costs, and that's going to affect the availability of capable contractors. So there isn't a one-size-fits-all answer. The board needs to make reasonable decisions based on all the information at its disposal. And again, should consult with legal counsel to the extent there are legal issues with contracts and with member concerns.
Okay. For a $3 million modernization project, not a repair, more so a glamour project, does the notion of a third-party safety person apply because it was not in the original budget?
So how many units are they working on, did they say? So if it's over,
No.
it's over 10 units and it's a construction project where the essential work or just a beautification upgrade, any large project in those counties, the third-party inspector is required.
Yeah, the issue here is not whether the work is discretionary versus mandatory in some fashion, whether it's mandatory for health and safety, or the building department has red tagged the building and said no one lives here, and that's the worst case scenario. Nobody lives here until you proceed. As opposed to, well, we've been budgeting this for 10 years and it's time and we've started doing it and we didn't have to do it, but we want to do it. There's the same analysis in terms of which protocols you need to comply with, and they're the contractor's burden. As to them not being budgeted, they weren't budgeted by the contractor either, which gets back to looking at your contractor more in the spirit of a business partner trying to help solve your problem, and maybe working with you to evaluate the scope of work and what might be modified to take into account the unanticipated costs that nobody anticipated, nobody could have foreseen, and you can't get away from.
Okay. How do you foresee?
I do see a couple of the questions because we're able to see them. Just to tell everybody, some of the questions are pretty detailed and fact specific. about a situation in your community, we probably aren't going to be able to respond meaningfully to those types of questions in this format. We urge you to come to the next ECHO show or seminar or other gathering where it is more interactive. But some of the questions that go into an intense factual background, there really is no way to fairly deal with them in this format. So some we may not be able to get to.
All right. I think this is more of a question for you, Bill. How do you foresee construction project insurance being impacted by COVID-19 and the new construction safety requirements? Will insurance go up, or it will be hard to get?
Well, the only insurance, well, there's two different things. One, and I have the initial question I had to our carrier that carries our pollution policy is that if we had a job site become contaminated, whether or not the pollution policy would cover the decontamination. Initially, they thought so, but they haven't gotten back to me with a written confirmation of that. I don't know. I mean, if there's lawsuits that come out of it, it certainly would impact our liability policy. I think the biggest concern we have right now is if an employee does come down with COVID-19, it's basically our obligation to prove they didn't get it at work, or it becomes a workman's comp claim. So the question we had to our workman's comp company is, if we have a bunch of COVID-19 claims, how's that going to affect our XMOD? Because if our XMOD goes up, so does our workman's comp insurance, which also drives our costs up. So there could be some insurance issues with this, depending on how all this ends up ferreting out in the end.
Okay. If a contractor's employee is found to have tested positive, does the entire crew have to be pulled from the job? And what is the duty to advise the residents?
I think we covered that. I mean, our duty is to shut the job down and go through decontamination. We would notify the board, property manager, construction manager, depending on what the communication protocol is. And I think John kind of addressed the board having to deal with how to notify the residents and what circumstances it kind of.
Yeah, you'd want to talk to legal counsel before doing anything further in terms of whether to disclose, and if the answer to that is a decision to disclose, in what form and what information is shared.
Okay. If an owner receives approval to modify their property, must they comply with the small construction safety protocol? Is this a new condition of approval for the HOA?
It's a condition for your contractor to deal with. So whoever you've hired to do the work, unless you're doing it yourself, your contractor will need to comply with those regulations.
So, it does suggest an interesting point. When members are seeking architectural approval for improvements to their separate interest, it would be a very good thing for a condition of approval to include the owner's obligation to ensure that the contractor takes steps to comply with any health and safety regulations.
Does the inspection and cleaning or repairs of in-unit fireplace flues require containment in SF, San Francisco?
I'm sorry, can you?
Family homes, maybe.
Yeah,
the question was, does the inspection and cleaning of repairs in in-unit fireplace flues require containment in San Francisco?
So they're talking about, I guess, a chimney service coming in and cleaning flues. They would.
Yeah, I think that's what that is.
I'm not sure that a chimney cleaning, a cleaning service falls under construction.
Yeah, it doesn't sound like that would be a construction project. It's a vendor maintenance that wouldn't necessarily, that I don't think jumps out as falling within Appendix B1 or B2 and the small or large construction project protocols. But that is something that, in terms of compliance with any safety regulations, we can say generally any vendor that the association is hiring to do work on the property, there would be wisdom in asking the vendor to provide assurance that they are complying with any health official directives for the protection of residents. But that's really not a construction issue.
Should a project manager get the OSHA 30-hour certificate?
The construction manager, it's always nice if a construction manager has the OSHA 30, certainly not a requirement. The OSHA 30 requirement was for the independent third-party inspector. That was the requirement that came down from the health departments.
So which
project managers all have OSHA 30. That's pretty standard in our company. And then the folks below them have OSHA 10. So,
but something to clarify, your independent construction manager isn't necessarily what the large construction project protocols are referring to when it comes to the contractor's compliance burden to have an independent third party fulfill that role. This is the contractor's burden. Now, whether there may be interplay in that regard between construction manager and contractor meeting its burden is probably beyond what we want to discuss today, but those are not necessary, well, they're not one and the same. The contractor has an independent obligation, which is a separate issue from what the construction manager does. And these protocols don't relate to construction management. They relate to the contractor's burden.
Okay. How would these protocols impact individual HOA homeowners' construction projects inside their own units? What can or cannot the board do to redirect individuals' owners from moving forward with projects?
Well, I think Bill addressed that just a minute ago with the burdens are on the contractors to comply. In terms of whether the board takes a catch-all position that, and I know some of the urban condominium buildings have done this. They have suspended all interior unit improvements for a period of time. I think boards do have the authority to take some steps as applied to the entire building in that instance, if the board goes about it the right way. The board isn't required to do that. So if your board is concerned about anyone having contractors come on site to do work within units, the board should discuss that issue with legal counsel about the propriety of having a temporary situation where interior improvements that are not health and safety related are suspended for a period of time. Probably beyond what we can answer in a catch-all way today, but I would encourage you to talk to the association's attorney about that specific situation.
Okay. And Bill and John, do you guys want to go ahead and, if you want to glance through the Q&As and just kind of look at the questions, if there's any other ones that you think would really be beneficial to answer that so that everybody could hear?
I think one of them, the question was, is painting project the same as a construction project? They are contractors, it's considered construction, so painting does fall under these regulations. That's a good question. So.
There are questions regarding the association having insurance funds for, can a condominium association require the homeowner to sign a contract with a contractor while the association has received and is holding on to the dollars for repair of this unit from HOA insurance? And then there's another question for how long can an association have the money they got from HOA insurance for a specific project and not authorize the work? There isn't a one-size-fits-all answer. On the first issue, there may be questions about who performs which repairs using insurance money. And the fact that you have insurance money doesn't dictate when the repairs are performed, because an association's obligation to repair is independent from the source of funds. So my generic answer to all of this is it's all going to depend on the circumstances. The fact that it's insurance money doesn't necessarily change anything. And how long can you hold off on repairs? If somebody's unit has suffered a fire and they're unable to live in the unit because of the fire, there are a lot of factors to consider in terms of when the repairs proceed. And if the repairs don't proceed, there will be legal ramifications from that. again, that's pretty significantly beyond what we're trying to discuss with you today, which is the general burdens of the construction project protocols. Something that specific, you really need to talk to legal counsel, but the fact that it's insurance money isn't the controlling factor in most cases, in my opinion. It's the needs of all involved and the potential risks.
I saw one of the questions and on the COVID-19 compliance costs, and then what if a vaccine's found and it's lifted during a construction project. That's why we're trying to approach this on a weekly cost basis, so that if it does get lifted, we either not billing through for it anymore, or if it's part of the contract terms, it just gets a delete change order and taken out once the regulations are lifted, or they might be lightened and changed or something that affects how much we have to do, so hopefully reduce costs.
In that regard, keep in mind, change orders for additional costs, for additional unanticipated work needs, they can be additive. They can also be deductive if magically one day we wake up and those needs no longer apply. So the same rules that apply to sharing in the burden and who absorbs the burden would apply to who receives the benefit when the burden goes away, if we were lucky and that were to occur. There's a question here on a dry rot project. How is the large or small project determination made in advance if we don't know how many units might be impacted? In a condominium development, that it might apply. When we're talking about dry rot from the building exterior, we are largely dealing with common areas, so the unit analysis might apply to the number of buildings that are affected that house a certain number of units. Bill, would you largely agree with that?
Yeah, I mean, we kind of have to look at, a lot of it's going to depend on the configuration of your buildings and whether you're a condominium or a PUD, attached PUD or not attached PUD. There's a lot of different things that go into figuring that out. And, it could be a situation, not that I want to do workarounds and stuff like that, but, you may end up in a situation where maybe you contract multiply for different buildings to keep the contracts into the small unit category versus the large. It kind of just depends. So
there are a number of questions about how many units work in the common area in a single family community, condominium development, work in elevators in buildings that have so many units. With elevators, I would talk to your if it's maintenance or repair, I would talk to the service company about the extent to which the Appendix B1 and B2 might apply. And again, I do believe boards can defer to the contractor to determine what safety regulations and directives they have to comply with. But with that, the contractor needs to give the association assurance and accept responsibility for compliance, separate analysis from cost. In all of these questions, in terms of which applies, I would defer to speak to your contractor about what they believe applies and why, and ask them to give assurance that they will comply and that they're applying with the proper directives. And then, at that point, it really comes down to, well, what if a contractor applies the large project protocols instead of the small because it'll cost more money? And in large measure, the large protocols are really burdensome. If you have that level of skepticism that what really appears to be a minute project has the large protocols apply, I would speak to your legal counsel at that point in terms of whether in that situation you want to push back. But generally speaking, I would be reluctant to suggest that you push back, because the board doesn't want to be in a situation of being perceived or accused of cutting corners when it comes to public health and the protection of residents.
Okay, do you guys see any, we're about to wrap it up, but maybe time for one last question if you see anything that would benefit the group as a whole. If not, then we will wrap it up.
I think we've generally covered the various concepts as well as we probably can.
Okay. All right. Well, thank you very much to our speakers. Thank you so much, John. Thank you so much, Bill, for giving your time and expertise today. We greatly appreciate it. And thank you again to our sponsors as well, Hughes, Gill, Cochrane, Tinetti for sponsoring our Q&A session today, and also to our registration sponsor, OMNI Community Management. Thank you guys so much. And I do want to let you know about some upcoming ECHO events. The technology that benefits HOA boards, we have that available on our ECHO website. You can go ahead and register for that. That's coming up next Tuesday, June 2nd. And then the opening up of HOA amenities, that was, seems like there's a lot of questions today that would kind of fall into that presentation next Thursday. And that'll be available this evening to go ahead and register, and you can find that on our website as well. And we also briefly mentioned the community conversation that would be happening tomorrow at 4. And that will also be available this evening. I'll go ahead and put the link up for all you guys to register on our website if you'd like to attend that. That's going to be a really informal conversation with Mark Hughes on. And so, yeah, if you guys have any questions, you can feel free to email me, Hannah McCauley. And I hope you guys all have a great day. And thank you for being here today. Again, thank you, everyone. GB Group and Hughes Gill, John, Bill, thank you so much.
Thank you, everyone.
Thanks
Thanks
you.
for attending.
Have a great day.
Have a great day, everyone.
Bye-bye.